Now in this video we'll be dealing with what is res gestae. So merely reading this particular section we can find that a fact that is not an issue. There is a fact which is not an issue, but it is so much connected to the fact and issue. That particular fact forms a part of same transaction. In a To understand this in a more complete way, we'll have an example. For example, if a person uh, who has an injury on his head and runs faster, shouting that someone has injured my head, he shouts and he runs away. So whatever is said by the victim while running, even though it is not relevant, becomes relevant when it forms a part of same transaction. So that is res gestae. We'll have more examples for this. So this principle res gestae applies for both criminal as well as civil cases. Res gestae isn't a hearsay evidence. So the general rule is that according to section 60 of this act, whatever is a hearsay evidence, it is not admissible before the court of law, and the same shall not be considered. But uh, res gestae is an exception for that particular rule, that hearsay evidence is no evidence, right? So for that particular rule, res gestae is an exemption. The another example would be the same example: person getting stabbed by a knife by another person, and after getting stabbed, he runs away and he shouts that the person, so and so person, has stabbed me. He shouts and runs away. And in that particular incident, there are two witnesses who saw that incident, and two witnesses are testifying before the court as a witness, and the court shall consider the same, because whatever he shouted after getting stabbed forms a part of same transaction. It relates to the crime, and therefore it should be considered. And there are two important cases when we talk about res gestae. First is R versus Bedingfield. So this is an interesting case where a woman's throat would have been slit by her husband itself, and the woman comes out of the house and sees his aunt and says, "See what he has done." She communicates that to her aunt, and the aunt comes to the court and testifies herself that the husband of the wife had killed by slitting her throat, and the testification that is given by the aunt before the court of law is not admissible. The court would have held like that, because when her throat was slit by the husband, she was not present inside the house, and therefore the same whatever the aunt is testifying is not relevant. The court would have been taken that stance. So that is R versus Bedingfield, and in Ratanlal the court would have taken different stance, where wife in traditional times, when we call a person, does not directly uh, we cannot directly communicate to the whomsoever person we are trying to call. There will be an intermediary, and that intermediary only will connect the call to another person. So here in this case, wife tried calling a person, but she ended up speaking with the intermediary, that is telephone operator, and the wife says to the telephone operator that her husband shot her. So now the telephone operator comes to the court and testifies herself that the husband has shot his wife. Court in this case had held whatever that has been that is testified by the telephone operator is relevant, as it forms part of same transaction, and same will be the res gestae, and it is relevant, it is admissible as well. So in Indian legal jurisprudence, Ratan Lal versus R is a very important case where this principle of res gestae was born, we can say that.